morning, Ms. Bokako.
Good morning, DCJ.
Are you ready?
I am ready, DCJ. Thank you. Good morning, commissioners.
How are you today?
Quite different, but I'm well, DCJ. Thank you.
You'll be fine, don't worry.
Thank you.
You hold 3 degrees, an LLB, an LLM in international law, and an MBA.
Indeed, DCJ.
And these were obtained from the University of Zululand. I imagine it would have been the University of the Natal at the time.
I beg your pardon, DCJ?
Where did you obtain the LLB?
University of Zululand, which is different from UKZN.
Oh, I see. Oh, from Ongoy.
Ongoy, yes. Yes, DCJ.
All right. And the LLM you obtained from Amsterdam at the Freie University.
Yes.
And the MBA, I've never been able to pronounce this college's name. what is it called?
You mean the one in Amsterdam or the one for my MBA?
For your MBA?
My MBA, it's Regenesis Business School.
Regenesis?
Yes,
so
which I'm still studying with them.
Okay.
Yes.
I learned something today. You started working at the city of Johannesburg in 1990.
1990, yes.
And you were there until 2000, your CV says. What did you do there?
Well, I started, thank you, DCJ, for the question. I started at the very early age, immediately when I completed my matric. Obviously, given the circumstances that our parents could not actually immediately take us to universities. So I opted to study part-timely. At the time, I think I was studying with Technicon SA, and I was doing municipal law or municipal administration. That's when I joined the city of Johannesburg with an understanding that I just wanted to grow in the area. So I started at a very teething stage where I worked as within an admin office. I was doing records and having to keep file. Particularly, I was in the Department of Environment and with the inspectors and the health department, where I made it a point that it was my task in having to keep their files. Because at that time, we had a number of environmental inspectors that actually will go within the city, having to check whether things are in order. That's where I started. And then from there, I was even responsible in having to issue stationery at that time. And to me, that was really impeccable, DCJ, in the sense that I learned the basics, in terms of administration. Then subsequent to that, because the city is fairly big, then I had to join different sections, data as a data capturer at some stage, working with epidemiologists, and also I worked within the committee section. Committee section then was within the legal department of the city, whereby I was responsible in having to take minutes during the council's meetings or during different sections meetings within the city. And also, I think the last role where I was in the city, that's when there was an establishment of a center which was fairly unconventional within the local government environment. There was a creation of a human rights information center whereby it was some kind of an excitement, given the newness of the constitution and reformations and transformations that were taking place. So I ended up being in that particular unit, and the role that I played there, I was a junior manager, obviously having to conscientize, having to teach the communities about their basic social rights, and having to teach the councillors, because it was a fairly new phenomenon. I mean, if one looks at the history of the local government by then was said to be an institution that promotes social welfare to the communities. But during that time, I was part and parcel of the transformation in having to change mindset that people, they need to take responsibility in having to pay for their services whilst they are entitled and they're right. But the emphasis that I was doing mainly, it was to teach people and train communities in respect of their rights. Thank you, TCJ.
Thank you. That's a very good start in life. Well, I've always found that people who start working at a young age
Yes,
turn out well later in life. It builds character.
it does.
At the risk of offending the anti-child work lobby. So you decided to become an advocate.
Yes.
Yeah, and you had all this experience by then. You were a fully formed human being.
Basically, I was. And I think, DCJ, I was encouraged with the environment of the human rights sector. I think that's where I developed the passion. And I said to myself, because I'm more passionate about it, I think it's appropriate for me to get skills so that I can be in the position to articulate and in a position to assist where I can. That's when then I decided to go back to the university. And at that time, I was now fairly an adult. As you can see, DCJ, that I've spent about 10 years. I think I went to the university full-time when I was the mother of two, and I was, I think, about 30 years old, which is fairly unconventional, having to start being at the university full-time, but I suppose it was a good decision. It wasn't an easy decision, but it was a decision that I had to take at the time.
Yeah. Well done. So you were at the bar between 2003 and 2008, and then went to join government. You became a state advocate in 2008, but you were there briefly.
Yes.
And you joined the Public Protector's Office.
Yes, DCJ.
As executive manager.
Yes, DCJ.
Right. But you didn't stay there as well.
I didn't stay much.
You became a company secretary for the Joburg Roads Agency.
Yes.
For 3 years.
Yes.
Then the bar called again.
Indeed.
In 2013.
Yes, TCJ.
And that's where you are until now.
Indeed.
All right. You have acted, I see, for a number of occasions, but I'm not going to ask you about that experience. I'll leave it to Judge President Lambo to do that.
Yes.
But let me just ask if you have had an opportunity. But first, do you have any reserved judgments from those acting stints?
So far, none, DCJ.
None.
Yes.
All right. Have you been able to write judgments?
Yes, I've written quite a number. Quite a number.
How many?
I think about 65, DCJ. 65 judgments.
So you say you've written about 65 judgments
Yes,
in
DCJ.
all.
Right.
Right. I wanted to ask you about something you raised in your application form, where you are asked to disclose if there's anything you think might embarrass you in this venture.
Yes.
And you mentioned that you owe SARS and you are currently working on it. Would you care to expatiate on this statement?
Indeed.
What is that about?
Well, in actual fact, it was my fault. I hadn't filed my returns. I think that was 2019, 2020, and 2020, 21. So that was an issue because of penalties, obviously, but it has since been resolved.
All right.
I've since filed DCJ. Thank you.
Okay. You have such an illustrious CV, and I'm really suitably impressed by all your achievements. But I was a bit disappointed when I went through your application form. For lack of a better description, it appears that it was carelessly completed. It's replete with typos, and just the manner it's been done that does not show that you took the exercise as seriously as you should have. What happened there? I mean, you misspelled obvious words. It's just a short piece of work that doesn't suit someone of your caliber. For example, where you are asked to outline your entire career in the law, giving an indication of your principal areas of legal interest and involvement at page 32.
Page 30.
It's a short paragraph, yes.
Yes.
Doesn't have to be long, but I picked up at least 3 typos there. You misspelled exams, you misspelled preferred, you referred to a commercial case when it should have been cases, you misspelled judgment, and did you complete this form in a rush?
I think I must have. I really apologize. I don't think I really intended to do a shoddy work. And I've just realized that indeed, you're quite correct, Mrs. J, that I've made some typos in that. Severely, I apologize to that.
The other aspect where you were asked to list not more than 10 of your judgments which you regard as being the most significant, you list them, yes. Then one, what you say is significant for is the fact that the accused, I imagine, were found in possession of stolen property. I don't understand what that means. And in another, you say my client was discharged of murder. And,
Which one is
and
that?
that's the tenor. This is at page 35 of the application pack.
Or where it 6.3?
6.3, yes. You say the case is most significant because these parties were found in possession of stolen property, and that's not the question. You are expected to give a substantive reason why this case is important, and that's the general tenor of your explanation for these cases you list. So this is what I'm talking about.
Oh, I see that. You're referring to number 2.
Yeah, instead number 2, you say the court found in favor. And I'm not sure why that would make the case significant. In favor,
What?
no unlawful arrest, detention of prosecution. Then the other one, you say very long trial and accused number 7 discharge of all counts. Then the other, they were found in possession of stolen property. Then the one I mentioned, my client was discharged of murder. And this is not, obviously not what this question is, requires from the applicant.
Yes.
You are supposed to, to explain as a lawyer why the case would have been important.
Indeed.
Now that shows that you did not apply your mind at all.
Will I be permitted, perhaps, DCJ, to explain? Thank you.
If you want.
If I may. Well, in respect of the first one, in paragraph 63, the first one, well, this is the matter that I'm currently busy with. It's a fairly significant DCJ in a sense that beside it being a long trial, but given the number of accused that are before court and the number of charges that are leveled against the accused, it's not your day-to-day matters within the criminal courts. It has to do with money laundering, it has to do with poker, it has to do with fraud, quite a number of extensive. So what is significant in this case is the dynamics within the trial itself, because we are different counsels in the matter, and the accused persons in the matter are fairly diverse and very dynamic in their nature, in that it's not just the accused that will sit and wait for the counsel to make submissions, but it's a fairly engaging matter in a sense that, if I'm not mistaken, there's quite a number of applications, interlocutory, if I may just coin it, in this particular process, which to me it is significant in that obviously I had to think on my feet, and continuously you get to learn a number of things in the process. That is why I've just indicated it, that it's a fairly significant matter. Now, in respect of the second one, I was a counsel in the matter. In actual fact, I was briefed by the state attorney, is the Minister of Police, against Quinike and others. What I found interesting in this matter, they were bringing the claim in that they were unlawfully arrested and unlawfully detained. So the issue was there wasn't a proper investigation in the matter to such an extent that the very same claimant, they were automatically released from custody because, according to the prosecutor at the time, said there wasn't any tangible evidence for such people to actual fact to be kept in custody. But I had to go deeper into the matter, understandingly very well that it was a civil litigation, but with the extensive background in respect of my criminal law experience, I had to dig much better so that I can be able to win the case. So that was very significant. Well, the reason why I'm saying that, there was an element of complexity or contentness from the applicants themselves to say we were not found in possession of the stolen items, but the factors that led to the arrest, I was able to articulate to the court. That is why I was able to get the order in our favor. In respect of the third one is a criminal trial as well, which took very extensive time at DCJ, whereby in actual fact in that matter I was representing accused number 1, which subsequently he was the only person that was released. He was acquitted comparatively to 11 accused persons that were found in court. Regardless of the situation and the facts that were before court, there were a number of confessions, number of pointing out of statements, and but I was able to work in the matter. But what was significant is that even at the time, you could see that the state did not have much evidence against my client. To such an extent, they went to a level of having to source the presence of an informer, which is fairly unorthodox in that an informer would actually come to court. But because there was an issue in respect of the evidence leveled against my client, they did that. And it emanated that the very same informer was not very candid with the court. And it was very strange as to why one will actually expose himself in having to come and tell the court as to what he knew. So that was fairly significant to me in that particular aspect. And then the last one, I beg your pardon, I think it's Peter Muklou, very interesting matter that has saved millions for the state. It's a matter of Peter Muklou and others versus the minister. I think they were suing for about, there were 4 claimants. In total, I think they were suing about 8 million, if I'm not mistaken. This case was fairly significant as well at DCJ, in that these were said to be the police officers that were actually arrested. And in the process, they got to be released from custody by the prosecutor with an understanding that there is nothing tangible, without really having to go deeper in having to do their investigations. But then I was able to save the state a lot of money. It's a very interesting case in that the police officer, whilst they were on duty, they were found wanting in having to steal certain items which was necessarily not due to them. So this was fairly impeccable on my side in having to save the cost for the state DCJ. Thank you.
Thank you very much, Advocate. All right, I'll leave it at this point for now. Maybe we'll revisit a little later, depending on how the questioning goes from the rest of the commissioners.
Thank you, DCJ.
I'll hand over to JP Mlambo.
Thank you very much, DCJ. Advocate Bokako, good morning.
Good morning, JP.
You've acted in Gauteng. You've acted for a total of 70 weeks, 70. You've got the spreadsheet in front of you, am I correct?
I do, correct.
And in your acting stints, the only court you've not acted in is the tax court, am I correct?
Yes.
Yeah.
Besides that, I was once confronted during a full bench appeal with a tax matter, though I was not a scribe in that matter.
Yes.
Yes.
You've done work, you've done 2 agent court weeks, am I correct?
Correct.
And I'll come back to how your experience was, and you've done 3 special motion weeks, as well as 5 opposed motion weeks.
Indeed,
Those are tough work areas, am I correct?
indeed, JP.
Yeah. Where in general is your strength and experience? Is it in criminal law or in the other side of the coin?
It's mainly in criminal,
Mainly.
but in the process, I got to gain some strength within civil.
Yeah. But I suppose as a black female from an underprivileged background, it's difficult to crack it in terms of the lucrative work areas, am I correct?
Indeed,
That's what determined where you gained experience in.
indeed.
Right. You've also written a total of 69 judgments according to the list that I've uploaded, I've given the commission.
Yes,
I know you understate it yourself, but it's 69. Now, my interest as JP of the division is to be able to recommend candidates who appear here who, in my view and in the view of this commission,
yes,
will be able to handle the workload of Gauteng.
indeed.
And I mentioned that deliberately. You've acted for a number of terms for the full term,
Yes,
and you have a good idea of what the full load is in Gauteng.
indeed.
It's easy to accumulate 20 judgments, reserve judgments, in one term.
Definitely.
Now, you are here because you regard yourself as ready to become permanent and do that kind of work continuously.
Indeed.
Am I correct?
You're correct.
Yeah. Let me just raise 2 aspects preliminary. One is the issue of reserve judgment is a problem in the judiciary.
Yes.
There are 2 judgments that are mentioned here which took you 7 months and over to finalize. The GCB says you don't explain why it took you so long. Are you able to tell this commission why you reserved these judgments for so long?
I can.
Please.
Thank you.
Don't go into details.
Yes.
Just explain briefly. Yeah.
Thank you. I think one which I recall, it was a full bench matter where I was sitting with other judges, senior judges. Obviously, I was assigned to be a scriber. So normally there is a process in me having to produce my first draft, having to give to other judges, and bearing in mind that other judges, they still have their work to do, and that could have been the cause in the delay, in particular to that, because it wasn't a judgment that was fairly easily, it was fairly complex. And it needed me to apply my mind, because I don't just say for the sake of having to produce, but quality is very important. So that is why I took my time, but bearing in mind that there is this 3 months, that's the first one. In respect of the second one, DJP, I beg your pardon, JP, I take serious responsibility on that one. I think that one really fell into the cracks. I don't know how I missed it, because I normally have my list of judgment, in particular when I have opposed matters. It's quite a number of them. But this one, it was total oversight. It's not necessary that I reserved it because I did not know what to do with it, but actually it was just an oversight, which I apologize sincerely on that one.
Thank you for that explanation. The other issue that I need to deal with regarding your candidature per se for Gauteng is the criticism that's been leveled against you in the comment from the GCB.
Yes.
Now, I want to state up front that I'm always happy as JP of Gauteng if people who are, candidates who are technically competent,
Yes.
who show themselves in what they've produced, technically competent and hardworking,
Yes.
but above all, conceptually savvy
Yes.
in terms of the law, in terms of the cases they deal with. If they fulfill those 3 competence, I usually am happy that they are suited to do work in Gauteng.
Yes.
Now, the criticism from the GCB raised serious issues and suggest that you don't meet those requirements. You've seen them.
I've seen that.
One probably is the easier one. Not easier, but it's very obvious. It's the one that DCJ pointed out.
Yes.
That in your completion of the questionnaire, it was a shoddy piece of work. But the judgments, the comments say this shoddiness also manifests itself in your judgments. Typos, grammar, but more than that, the GCB points to weak legal reasoning. They point to you citing passages from other sources in certain instances without explaining why you're citing those authorities, those passages, and in certain instances without acknowledging where you're getting these sources from.
Yes.
This is serious criticism. You are aware of it. I'm giving you the opportunity. That's why we are being interviewed, to explain us if this criticism is valid, and if you don't agree with it, to tell us why you don't agree with it.
Thank you. One, I think I need to indicate that I take criticism very positively and seriously. I've looked at the cases that they've made reference to, in particular the case that was a constitutional court judgment that had actually written. I've seen my weaknesses in it, though there are certain level of strength that I saw in it, and the peripheral, these mistakes of typos, I've taken that into cognizance, and I don't know why it happened because I do concentrate to detail, but I'm taking them very positively because to me, it says you can do better, which I'm prepared to do better. And beside this particular one, when I work with other senior judges, obviously this becomes the process in me having to submit and them having to critique and make correction. And immediately when they correct me and show me certain mistakes, I work in them and there is an improvement. I mean, if one can look at some of my judgment that I did, in actual fact, I acceded to the call because I totally believe, JP, that I'm a product of mentorship and I take counsel very seriously. But in respect of the reasoning of the law, I suppose it's a skill that continuously I am learning and I'm developing in it. That is why even currently I'm still studying. And for me to continue to study in doing my doctoral studies is also to assist me in having to improve in terms of being a good orator, improve in terms of my writing skills, improve in having to have an IQ, in having to analyze and give reasons. It's not an easy thing. I know it's easy for one to come up with an order, but having to deal with the reasoning aspect, I think it's an area that I am quite committed, that I can be in the position having to improve on that. But in respect of their comments that I've made, I've taken them into cognizance. And I do appreciate because it makes me to sharpen my skills and to be abreast of what I'm doing.
Yeah.
Yes.
The commission has been interviewing candidates for the week.
Yes.
And in this week in particular, it has established a certain bar
Yes.
that candidates who've appeared here who were technically deficient or not up to the required standard, as well as conceptually weak,
Yes.
were not recommended. That's what this commission has done this week. It's done so, I think, in other sittings, but I'm just bringing it to your attention because you were not here.
Yes.
These comments suggest that that's the case with you, and I'm giving you the opportunity to sell yourself.
Yes.
Yeah, please.
Thank you. Thank you. I appreciate that. What I can simply say to the commission that I've crafted, like the JPA indicated, it's about 69 judgments. Then what the commission is exposed to is the judgments that are here. And what I can simply say that I have grown. Some of the judgment that I've actually crafted, I think they date back to 2019, which I was still teething, in particular on the aspect of civil law, but I have since grown as a person. I mean, now recently I was crafting my heads of argument, and now I've got a different way of thinking and different way of having to interpret principles of law and having to make it succinct and clear to the point, because my previous judgments were fairly lengthy. I do take that into cognizance because I think I seem to dwell much in having to read and understand the facts, and in other instances you may find that the issues of law that are before me, it's something that I've never dealt with as a counsel. So it's very primary for me to understand the facts and understand the issues and make it a point that I tend to be content about it. And also I think the other issue that causes a delay and some mishaps in this, I tend to dwell much in having to research the law. So that on its own, I take comfort to say, at least if I understand the principles, I understand the facts and understand the issues, then I am in the position to produce good judgment. But I can assure the Commission that I am amenable to change, I am amenable to learn, and I know for a fact that there are programs in place that actually takes junior judges for training purposes so that they can actually improve in respect of their writing skills. Like I've indicated, JP, in that currently I am studying, and the area of my study it's mainly on research, and on daily basis I'm learning new things as to how to craft, how to concentrate on issues, how to focus on things that are primary. So with that, to me, is a bonus that is going to be invest positively in what I do in respect of my judgment writing. Thank you, JP.
Thank you for that explanation. One last question. You mentioned that there are programs. I know in Gauteng, whenever acting judges are appointed, when they request to be paired with a mentor, we do that.
Yes.
But we say it's up to you as an acting judge to knock on a permanent senior judge's door that you feel comfortable with.
Yes.
To talk to,
Yes.
to give their judgments.
Yes.
Now, the general report I get from judges is that acting judges don't take kindly to being criticized and being told, this is not correct, this is shoddy, this is how you do stuff. And a number of acting judges who have that problem don't expose their weakness and cry for help to senior judges.
Yes.
And sometimes that manifests itself in these judgments that they write, going into the public domain.
Indeed.
They didn't mention you. I'm
Yes.
just saying that's what I've heard, that acting judges in general tend not to accept criticism. But it's there.
Yes.
Now, these judgments that are being criticized, did you seek senior judge assistance with these judgments?
I remember with one, in particular the constitutional one, because it really, really worried me. It's an area that I was not comfortable with. I'd actually requested 2 judges. So it so happened at the time, that is why it was actually delayed as well, because I'd actually sent to 2 senior judges, so that if they can just have sight and see that it's coherent and see that there's logic and see that any other person when reads the judgment could actually understand what I'm talking about, with an understanding that I'm not only writing a judgment for advocates or lawyers, but it's a public document. So it so happened that those judges, even though they were keen in assisting, they were quite busy. And they were quite busy. So I wasn't in the position really to push them to say, I've got a deadline, because that's my responsibility. But to confirm your word, I'm one person who's not scared, JP, in having to knock in people's doors. I'm one person who's not scared to place myself to be vulnerable on issues. And that's how I learn. I suppose that's how I develop in the process. And moreover, the other area which I did not make use. Now I know that I can actually make use. We do have researchers, and I'm made to understand that they're very good, even though there might be few, but they can be of great assistance in having to take my judgment to them, let them look at it, and let them having to see whether the law that I've actually applied, it's relevant and it's correctly interpreted. And I think in the process, they can be in a situation to correct and edit where I went wrong. So I think I have those avenues in having to make use of them.
Yeah.
Thank you.
DCJ, that's it. I just want to just deal with this last aspect. I can confirm that the research units of Gauteng, no matter how small, if they find something seriously wrong with the judgment, I've told them they should not be scared to point it out to judges.
Yeah.
And I know that in general, acting judges don't use the researchers. I don't understand why, but they are there. Thank you very much, DCJ. I don't have any other questions.
Thank you, JP. Good morning, MEC.
Good morning to you, and thanks. Can I?
It's your turn to ask questions if you have any.
Yeah. Good morning, Advocate.
Good morning.
And thank you very much. My question, I've got only one question to you, and it flows from the replies that you have just provided in the two conversations you had with the DCJ and the JP
Yes.
Gauteng. And whilst I think in the responses you have given me comfort that where there are clear weaknesses, challenges, and of course some mistakes, you do take responsibility for those and frankly and acknowledge them and commit to work on them.
Yes.
And secondly, I do appreciate the point you're making about your commitment to further studies to make sure that you improve the quality of your application of the law.
Yes.
And all that. But while that's positive for me, I just need you to take me out of this bit of dilemma that I have, that with all that being said, we still have a responsibility to put into the public space confidence that if you are recommended for appointment, those things will not persist, especially the quality and integrity of decisions and judgments that you'll be responsible for. And these are the two things. So your honesty, frankness about the issues, highly remarkable. But on the other hand, we've got a public out there to say, here is a good candidate, and deposit that level of trust and confidence in the public. And the two things for me create a bit of a dilemma in that I'm happy with one, but I still have got, issues, because when all is said and done,
Yes.
the credibility and integrity of judgments and decisions made, it's what matters.
Yes.
And I can tell you, for the period that I've been MEC in this province, we have been having difficulties with some of the quality of decisions that comes out of courts. So just give me the comfort there that, the public and everybody will sit comfortably that these issues will not persist, because there can't be permanent learning, correcting. At some point, we have got to have the assurance that, we have reached a critical point where we can sit comfortably with whatever, including administrative work, decisions, and all that.
Yes.
If you can just talk to that. Thank you very much. That was my only question.
Thank you. Thank you, MEC. I totally agree with the MEC that at some point in life, you need to reach a point of saying, I'm content with what I do. But having to respect the process in having to build towards that particular goal. But like I indicated, that I'm a product of mentorship, and I'll continuously listen and I'll continuously improve. I mean, if I do my own self-introspection, I see that there's been change thus far. Obviously, change is fairly relative, I think, but in respect of me having to assess myself, I think there is a serious change. And I'm very optimistic that should I be given an opportunity, definitely I wouldn't disappoint the community. I wouldn't expose the judiciary to things that are not correct. I'm fairly committed in having to promote the rule of law, obviously through my judgment, through my reasoning, through the logic, and appreciating what is happening in our surroundings. I'm fairly committed to that. Thank you.
Thank you, MEC. AP person?
Thank you, DCJ. Good morning, Advocate Bokako.
Good morning. Good morning, Commissioner.
You are presiding in a civil trial
Yes.
concerning a delictual claim for patrimonial loss. The only issue which is contested by the defendant is negligence. And what test would you need to apply to determine whether the defendant was negligent as alleged by the plaintiff?
Thank you for the question. I think it's the reasonable men's test and foreseeability.
I beg yours?
I think it's a reasonable men's test.
Yeah.
You're making reference to negligence.
Yes.
Yes.
Could you elaborate?
Well, for an example, let me just make reference to medical negligence, whereby there's an issue with an obs and gynes during birth. It may happen that obviously the claimant will raise that there was some negligence. It may happen that a doctor in question at the time, or the staff that is supposed, the midwife that are supposed to be taking care of this particular woman, they are not effective and responsive in respect of the process. Now, the question one that will pose in the aspect of a reasonable man test is that any reasonable person would have foreseen what was going to happen. For an example, it may happen that the hospital is just overcrowded and there's quite a number of women that are giving birth and there's a shortage of staff. Now, a person maybe that is fairly new had actually attended to the patient. Now, one will ask whether this person, did he or she foresee that if she or he does not engage the services of an expert, being the gynae on an obs at the time, would not have led to this particular situation. I don't know if it answers the question.
Is that your complete answer?
Yes.
Thank you. We'll leave it at that. You are sitting as a member of an appellate court
Yes.
in an appeal against sentence by an accused person.
Yes.
Under what circumstances would interference by the appellate court be warranted
Thank you.
with the sentence imposed by the trial court?
Thank you. Under normal circumstances, the appeal court is not expected to interfere really with the sentence processes. Given the circumstances at the court of call, where the presiding officer was actually exposed to the processes. But then the question as to when can actually the appeal court can actually interfere, there are some instances. Should it happen that the person was actually convicted, either charged with murder and convicted for murder, but then when you look at the circumstances as to how that occurred, it's easy for the court to see whether was that particular action premeditated or was that situation action of necessity, provocation, or self-defense? And you find that there is a prescribed minimum sentence in respect of premeditated murder, whereby a life imprisonment, that's a prescribed minimum sentence. But if the appellate court is of the view to say the action does not justify the punishment, in that particular instance, the court can actually interfere to that, to say, let's rather look at the facts as to what led to this particular instance. And the other issue, it pertains to the aspect of substantial and compelling reasons, in that if the appellate court is actually convinced that there are substantial reasons that they could actually deviate from this particular sentencing, the court can actually interfere to that particular situation.
Thank you. I'll leave it at that.
Thank you.
Thank you, DCJ.
Thank you, AP. Deputy Minister?
Thanks. Good morning, Advocate Bokako.
Good morning.
Just a quick issue, and it should have really been a follow-up question, but clarity on the SARS issue, which the DCJ had asked you about. On the form, you'd said, I'm currently owing SARS.
Yes.
And you're working on it. When she questioned you on it now, you said that it related to 2 years of tax returns that hadn't been, or 2 years tax returns that hadn't been submitted,
Yes.
and you've done that.
Yes.
Are you currently owing SARS?
Well, because of the penalties, yes, and I've entered into arrangements.
Okay, so you're not overdue, you're not in default or anything like that with the payments?
No, I'm not.
Okay.
I'm not.
Thank you.
Thank you, TM. Commissioner Nyambi?
Thank you, DCJ. Morning, Advocate Bokako.
Good morning.
One question from my side.
Oh, thank you.
After the interaction with JP Mlambo,
Yes.
maybe if you can share with us the challenges facing judges in the division of Gauteng.
Is it like acting judges?
An experienced acting judge.
Yes. One, it will be my personal experience, or rather experiences, in that when you act, obviously it's for a term. In other instances, it might be lesser than that. And you may find that at the time you are busy with other matters, which that's what happened to me in most instances. In that immediately when I'm done with my stint of acting, I have to immediately go to court. And the matter that I was busy with is the matter that called me to be in court on daily basis. So the challenge that I face in having to balance my commitment in having to represent my client and having to produce the judgment, that's the challenge that I had. In that I have this 3-month period that I need to excel and produce quality whilst I'm expected to represent. So those are the challenges that I've experienced. But in any other instance, I think if one could say there are many, it could be out of my own action in having not to utilize the resources that are there. I haven't found anything administratively, Commissioner, that was some kind of an impediment. In actual fact, with the new system of case line, it's something that is fairly impeccable, and it becomes an enabler to say one could be anywhere to work. You don't have to carry a number of files. So those are the positive thus far that I've realized as a person. But in respect of challenges beside the workload, I mean, it's given. Like the JP has indicated that if I'm sitting in an opposed motion, you may find that I come up with a number of judgments, and they come within a week. And when you look at the time frame of all these judgments, I have to produce them within 3 months. So those are the challenges that personally I had, but I've since improved in that particular aspect. But any other thing, I just see the positives, and what is good, which I think is important for me to emphasize, that it's an open door policy of the senior judges. They're fairly welcoming. I mean, anytime they'll say, Thembi, should you need any assistance, please knock at our doors. So that's what I've experienced, Commissioner. Thank you.
Any weakness from your party that you still have to work on?
It's time management. It's time management. I need to be honest with that, in that I really need to master my time. But then in this situation, it was the case that I was busy with. I think it took a lot of my time, but now I've worked on a system and thus far it works. And the other way of improving, Commissioner, is that when you are exposed to the matter as we were trained, is that you deal with the matter immediately. At least come up with a draft within a week, because the issues and the facts are still fresh, and then it will be easy to move forward. So the delaying in having to come up with my draft, that was the weakness. But now I've since created a system in place which is workable.
Thanks, Advocate Bokako. Thank you, DCJ.
Thank you, Commissioner. Commissioner Dudu?
Thank you very much, DCJ. Just one question. I can see that you presided over the case of the infamous advocate Maloisane Tefo, where he was charged for contravening the code of conduct of the LPC.
Indeed, Commissioner.
In your view, how widespread is this problem in the whole ecosystem of the judiciary? And what is it that can be done if it is quite serious to uproot it?
Thank you. Thank you, Commissioner. Indeed, I presided over the matter. I was sitting with a senior judge, which is Judge Nyati. The issue of practitioners finding themselves in this unwarranted situation is fairly prevalent. I think, in my personal point of view, Commissioner, there are a number of dynamics within our profession. If I may just relate to attorneys in particular, because those are the ones who deal with the public purse. There are a number of shortcomings in having to understand as to how it's expected of them having to run the business. And when I looked at that, I looked back at the university where I studied, that when I was prepared to be a lawyer, there was never any course that prepared me to be an entrepreneur, or there was never a course within my curriculum that suggested that I need to have an understanding in respect of business management. Now, when desperate time comes, desperate measures prevails. I suppose with some of the attorneys thinking that they cannot be found, then they go to the kitty in having to take what is not due to them, with an understanding that in future they will take back the money. But the essence is, I think we really have to conscientize ourselves as legal practitioners that we need to have a certain kind of value system. Value system in that we respect the rule of law in particular, and ethics, and we also respect our clients. Because with this case, I think it was bothering in an attorney having some kind of authority or power over the customers. And most of the customers, you'll find that they were at his mercy because a number of them were actually dismissed from the workplace. For an example, I'll make an example of the police officers. They just want to go back to work. They see they've got a legal representative that has an energy and the drive in representing them. Then they entrust him with that. But I think he generally failed them. But the emphasis is people need to continuously be sensitized to say you are taking responsibility in people's lives and statuses.
Just on a lighter note,
Yes.
the other day I saw the caption of a photo of this advocate with Advocate Ngaitobi, with a caption on the same level. Thank you.
Thank you, Commissioner.
Thank you, Commissioner. Commissioner Moimang?
Thank you, DCJ. Good morning, Advocate Bokako.
Good morning, Commissioner.
Yeah, just one question from my side. Section 165 of the Constitution makes reference to the independence of the judiciary. So my question is whether the independence of the judiciary, is it meant to protect the judiciary itself, or is it meant to protect the individual judges? Thank you.
If I understand the question correctly, is it meant to protect the judiciary or the judges themselves?
Yes, you've captured it quite well.
I think it's twofold. Independence in respect in having for a judge protect him or herself. You really have to coin what you think is appropriate without any coercion, without any influence. That protects the judge. In that, as questions are being posed in respect of my judgment, I need to be in a position to take responsibility and answer in my reasoning. That deals with the personal protection of a judge. Then, in respect of the judiciary itself, it's about integrity that we need to show the communities. And it's not only even for the judiciary, it's for the community itself, that they have trust and believe in us, that we are actually impartial and we are actually transparent and we are independent in what we do, just creating trust to the communities. Thank you.
Thank you, DCJ. Thank you, Advocate Bokako. Thank you, DCJ. Good morning, Advocate.
Good morning, Commissioner.
I have a question for you. And I'm happy that you are specializing in criminal law, because there is something that has really been troubling me in my mind generally. Because I don't know to what extent judges generally read or have regard to Section 280 of the Criminal Procedure Act. No, don't worry, I will help you with it. I'm not good, because I understand this is not a test.
Yes.
It deals with cumulative and concurrent sentences. And I've read your judgments, especially Serake, Mutsweni, and Khobani. I'm not sure if you remember those.
Yes.
I'm not going to burden you with the facts.
Yes.
And the issue of cumulative effect and concurrent sentences comes out quite extensively in those judgments. Now, I just want to understand, given the fact that a crime in South Africa, it is what it is.
Yes.
And you find that people are charged with multiple counts and they get convicted of those crimes. Do you think that judges generally are of the view that ordering concurrent sentences, it's a matter of course? In other words, it's not discretionary. Because it seems like in every other case, sentences are continuously being granted concurrently.
Yes.
And there is a public outcry where somebody has been charged with 7 counts and is convicted, maybe it's like 5 years, 7 years, 8 years, 10 years, 20 years.
Yes.
And effectively the person has been convicted for 20 years, and after 7 or so years comes back. Is this not a challenge? Perhaps maybe Section 280 is not really being taken seriously by the judges, given the extent of crime in South Africa.
Right. Thank you, Commissioner. Well, there's normally a phrase that even if a person is actually charged with 7 lives, a person's got only 1 life. That's the essence of concurrency. I understand the dilemma that you have, and I strongly believe, Commissioner, that even if a person could actually, well, I'm talking in my personal, as a person, since I've been a counsel in respect of criminal matters, that even if a person can actually be sentenced for 70 years, there isn't any guarantee in that there could be a redress that is sufficient to make the communities to take comfort. Even if a person could be in custody or in jail for 15 years, when they come back, the community will still have an issue about it, not understanding that this is a prescribed minimum sentence, for an example, in respect of robbery. Now, the concurrent, it's mainly applicable, for an example, when a person is charged with murder, is charged with robbery, possession of ammunition, and firearm. And you'll find that the smaller sentences, obviously, they get to be taken into the life sentence being 25. So that's the concurrency in respect of having to impose this particular sentencing. But what I think is more fundamental is on the issue of sentencing is an emphasis that one sees in Zin's case, which is a fairly popular case law, in that if one will have to impose a sentence, you need to have a cognizance as to why are you sentencing. One, either to rehabilitate the person, or the other one is to deter the person. And there's quite another elements. So one can ask whether even if you take them for life, are you deterring them? Because they come back in the very similar environment. I think the issue, Commissioner, in answering you, it's not only the sentencing that are being imposed, is the environment where we find ourselves in, because I strongly believe, Commissioner, that in us having to curb the issues of crime and keep away people that are said to be unwanted in our communities, it's not only the court's role in having to play that. There's quite a number of social effects that contribute. If I can just make one example with your permission. There was a case, a matter that dealt, I was a counsel in the matter. It's the matter of a number of accused persons that belong to two different political parties. And it was an area of a squatter camp. So the concentration of the court in respect of mitigation pertaining to sentences, yes, she convicted them, but she had an interest in having to look at the social circumstances, besides her having to make a decision in having to take them to custody for life. She was interested to say, in us having to cap this reoccurrence, let's go deeper. To such an extent which it was unorthodox or unconventional for the court to suggest that we need a professional person to come out with a proper report so that it could be a persuasive report to the court in relation to the social circumstances. Because normally when we argue in court in respect of lesser sentences, we mainly look at the personal circumstances of the person. But that court, it wanted to know the social to such an extent that we were actually assigned to go to that particular community to see the circumstances. And if one looks at the circumstances, it created a different mindset if one will have to argue and present the mitigating factors to the court. And to me, that was plausible. That was plausible to say the court can actually be convinced to say, I'm not only have a homogeneous approach in respect of the accused, that it is a known fact when they kill somebody, they need to be taken to custody for life. But the court looked at the deeper factors to say how best the court or the justice system can actually assist in having to curb crime in our communities.
No, well,
Sorry, Prof, just before you carry on, Advocate Bokako, I'm really enjoying listening to you, but in the interest of time, we still have 8 other candidates to interview and the day is short. Could I just ask you to be a tad, just a little more concise in your answers?
Thank you.
Thank you so much.
perhaps DCJ to assist as well, let me leave it here.
All right. Commissioner Makwanesh?
Thank you very much, DCJ. Good morning, Advocate Bokako.
Good morning, Commissioner.
I have 2 quick questions. One is influenced by what you indicated to us on page 31 of your paginated documents. Are you a member of a political party currently?
No, I'm not currently.
Thank you very much. Then this one is a comment, which I think your response will be helpful. Given what you have admitted or what you have promised to do when both the Judge President and the Deputy Chief Justice were having a conversation with you, that you are working very hard on working on the improvements.
Yes.
What would you say to a person who would say, no, this body would at least need some comfort by seeing that those improvements before recommending you, meaning that between today and the next time you come, we should have seen those improvements before recommending you? What would you say?
Can I just get the question again, Commissioner? I think I lost it somewhere.
Okay. What would you say to a person who would say that you made certain commitments about your own improvement?
Yes.
That this body, before recommending you, they
Yes.
would want to see that indeed you have improved from the last time you came, which is today.
Yes. Well,
So in that case, then the view would be, let's say, if you come the next time and would want to see those improvements, what would you say to that?
definitely you'll see the improvements. You'll see the improvements, Commissioner. There are actually improvements, judging from what I've written at the later stage.
Thank you very much.
Thank you.
Just a follow-up, quick follow-up, DCJ.
Sorry? Yeah,
Follow-up.
carry on.
No, the question is, what if we say we shouldn't appoint you now with the hope that when you come next time, there will be some improvement from all the criticisms observed here? Do you think will be unfair?
That's a difficult question, Commissioner Malema. I'm fairly optimistic that the Commission will be amenable and in giving me the opportunity, to say I'm a candidate of improvement. I've shown with my judgment that I can do better. So in having to say to the Commission, no, I'll come back the second time, I think I'll sound like a pessimist. I just want to remain optimistic to say I'm doing good and I'm doing better. And the continuous exposure, I'm currently acting as a judge, it's an exposure. It's giving me an opportunity to say, Thembi, do better. So I'll appreciate if the Commission could actually decide contrary, Commissioner. Thank you.
Shouldn't we give you more extension through the JP of acting? Thank you, DCG.
I'm available to serve. I'm available to serve, Commissioner.
Commissioner Kane?
Good morning.
Good morning, Commissioner.
You would have, I presume, read the report from the GCB pertaining to an overview of your judgments thus far.
Yes.
Have you done that?
Yes.
And you would have seen that they criticize you for not actually applying the correct legal tests established by precedent.
Yes.
And this is an opportunity then just to explain, if you've had a good look at that, how you would deal with it now. One of the examples they give of that failure, for instance, is not applying the requirements for an interim interdict when a bank actually sought the return of a motor vehicle. You've seen that criticism?
The Mulimi, I think it's Mulimi.
It's paragraph 6.5, APSA versus Mokatimi.
Yes.
Now, could you explain to the Commission what the difference would have been if a final interdict had been sought in this case? What test would you have then applied?
Right. Obviously in interdicts, there are two, the interim And the final one, with an interim, obviously the court will have to look at the prima facie case, will have to look at the injury, apprehension or irreparable harm, and then the test then in respect of the final interdict will have to look at the clear right and irreparable harm, and also will have to look as to whether is there any alternative remedy to the situation. So I suppose in the matter that I dealt with, it pertained to an interim interdict whereby the applicant actually needed the respondent to
Yes, all right. I'm going to stop you because you've dealt with my question and we're pressed for time.
Thank you.
But I just want to now take you on to other kinds of interdicts that are ordinarily dealt with by high courts.
Yes.
For example, a mandament van spolie. What sort of test would you be looking at there?
I think it's possession,
And what's the test?
whether the person was in a peaceful possession.
And would the right to ownership be relevant in those circumstances?
No, it's not relevant.
And then an Anton Pillar order is another example. What would
Yes.
be the purpose of such an interdict?
Anton Pila, I think, Anthony Pila, I think it has to do with recovery of documents.
Let me assist you. You are correct, the preservation of evidence.
Yes.
Now there, would you be exercising a discretion?
You do exercise a jurisdiction, particularly when the applicant can actually convince you, the presiding officer, to say particular evidence or information is at the disposal of this particular person, and there are probabilities that this person can actually dispose of the
All right,
document.
You said that you would exercise a jurisdiction. Did you mean a discretion?
A discretion, I beg your pardon.
All right, and what really is the test there? How are you going to apply that discretion?
The imminent irreparable harm in having not to secure particular evidence,
As against?
as against having to notify the person, because normally in those particular processes, there isn't any requirement or obligatory having to inform the respondent, because as soon as you do that, they get to be aware and it's easy for them to dispose with that particular information.
Let's take another example, an application for an eviction. Are you exercising a discretion there, and how are you going to be guided?
Eviction, knowingly, is guided by PI Act. It has some requirements. Well, one is led by the prescription of the legislation, and in other instances, obviously, is the facts that are presented before you. Discretion can come into the picture whereby there are elderly people within that particular household, there are young people, so that it has to be discretionary in having to take that into cognizance.
Thank you, DCJ.
Commissioner Baloyi?
Thank you, DCJ. Good morning, Ms. Bokako.
Good morning, Commissioner.
Ms. Bokako, I've looked at the judgment of the deformalisela defo that you discussed earlier with Commissioner Dodovu.
Yes.
And the reason I've looked at it is because it's a very recent judgment.
Yes.
It's in September 2022. When did you start your first stint at acting?
2018.
And you say you've written how many judgments?
About 69.
About 69.
Yes.
And this is one of the 69 in
Yes.
September 2020. Now, the judgment is replete with errors of reasoning, structure, typos, and it's very difficult to, I don't know where to start. So I'm just going to pick randomly an example that I want to make. But before I do that, let me ask you this. In that judgment, at paragraph 133 of the judgment.
If I might just go there.
Yes, please.
Commissioner. You
One,
said
133, are you there?
133.
Yes. You say in that paragraph, you start off by saying it is trite that in this is a striking off. You say it is trite that in application of this nature, there is no less between the applicant and the respondent, right?
I beg your pardon, Commissioner, I think I'm in the wrong page. 133, according to my bundle, is
Paragraph. The Malisela judgment at page 100, handwritten page 100 at the bottom of your bundle, and then the stamped case line 01847-47.
I found it.
Okay.
Yes.
So you say it is trite that in application of this nature, there is no less between the applicant and the respondent. The applicant is, by virtue of its statutory duties, furnishes the court with the relevant facts and findings. Now, my understanding of what you are saying there, and please correct me if I'm wrong, my understanding is the duty of the LPC as a regulatory body in these kind of situations is not to prove a case, it's just to come and assist the court, to be of assistance to the court. Am I correct?
Correct.
Okay. And then go to page paragraph 143. And there you say, in the second line, you say this, the second sentence, you say, this court is satisfied that the applicant has proven its case on balance of probabilities that the respondent is not a fit and proper person, right? You say that. Now, that's the opposite of what you said earlier. You're saying here the LPC had to prove a case and it has done so. So the reasoning is completely wrong, and there's lots of it in this judgment. And the reason I raise this is you've been acting, your first acting stint is 2018. This is a judgment in 2022. It doesn't seem to show development and growth. And I've just picked an example, but this whole judgment suggests there hasn't been any meaningful growth over time from experience of writing judgments and reasoning. How do you explain this? Because it's a bad judgment. How do you explain it?
Well, Commissioner, without me being defense, I think I take your cue and take your counsel. I did realize that in actual fact, I could have done better in my reasoning in this particular aspect. I see that it's fairly minimal. So I've taken that into cognizance.
Okay.
Basically, that's what I just want to say.
All right. So that's my one concern. It doesn't seem that you know, over time you have grown to a point where today we should be confident to recommend you. That's the one. The second related issue for me is when you were answering, I think it was Commissioner, one of the commissioners on the other side, I don't remember which commissioner it was, you were discussing about reasoning being a skill that will develop with experience over time, and you're bettering yourself, you're studying. Now, my difficulty or the problem that creates for me is, as a judge, and that holds true as an acting judge too, is you make decisions that affect people.
Yes.
You make decisions that affect people. And I think it is unfair on the public, would be unfair on the public for us to say that, she should be appointed as a judge. She will grow in her reasoning capacity to the extent that's a thing. She will grow in her reasoning capacity, but in the meantime, the public has to put up with this deficiency of reasoning in the judgments that she makes. That makes me terribly uncomfortable. I don't think that I could recommend that of any candidate, that they should be appointed and they will grow over time, and in the meantime, the public must suffer the consequence of this deficiency, because it is very important. What do you say to that?
I hear what the Commissioner says, and it is not intended in me having to embarrass the judiciary and expose our courts in respect of this. But I can safely say, Commissioner, that I have improved. I understand you have raised the time factor, but if I compare this comparatively to what I had actually written, because all the time when I write judgment, I don't write with an intention of saying this is going to be less of a quality or better of a quality. I give it my all in doing it. I suppose by me being exposed to these circumstances is going to enable me to be a better analytical person or a person that reasons. So I can't take it any further. Commissioner, thank you.
All right, thank you, Ms. Bokako. Thank
May
you,
I follow?
DCJ.
Thank you, DCJ. May I follow up? And it will be my question as well. Thank you. Good morning, Ms. Bokako.
Good morning, Commissioner.
Ms. Bokako, I'd like to follow up on what was put to you by Commissioner Baloy and by Commissioner Malema. You've described yourself as a candidate of improvement.
Yes.
And I think what you're asking us to do is to give you a chance to carry on brushing up your skills while you're sitting as an acting judge. Commissioner Baloy highlighted the risks associated with that. And I just want to bring that down a bit and demonstrate to you how enormous the risks really are. And I want to do it with reference to your solidarity judgment.
Yes.
Now, you'll remember the solidarity matter comes to you when you're sitting in unopposed motion court.
Indeed.
And it's a huge application because it's a constitutional challenge to 4 sections of the National Health Act.
Yes.
But what was a crucial feature is that these 4 sections hadn't yet come into effect.
Indeed.
Because the proclamation which purported to do that had been set aside by another court as being unconstitutional.
Right.
Now, when one goes through your judgment, and I say this with great respect, because I accept that you've already said to us that you've got limited constitutional experience.
Yes.
But if one goes through your judgment, it's almost incomprehensible in terms of your reasoning, in terms of you dealing with the technical issues that were very prevalent in that matter simply because of the nature of the matter.
Yes.
For example, when you're dealing with the question of jurisdiction, you do the right thing, you refer to section 1722A of the Constitution, but that should have been the beginning and end of the discussion.
Yes.
You then go on and you ask whether or not the fact that the matter is not opposed,
Yes.
Whether you still have jurisdiction to determine the matter.
Yes.
So that's just a minor example, and the entire judgment is littered with errors. From the very beginning, when you talk about the applicant raising preliminary points, right to the end in terms of the order that you craft.
Yes.
So I raise this, Ms. Bokako, firstly with great respect, because I think what we do want to see is candidates of your nature being developed within the judiciary and eventually taking this position because they should. But it is of enormous concern that when you are discharging your judicial function,
Yes.
you're doing it in a way that has consequences.
Indeed.
And I think the solidarity matter is one such matter where the consequences are clear. So I want to come back to what Commissioner Malema put to you earlier.
Yes.
Do you not believe that given these real conceptual difficulties with your judgments, that you will benefit from acting a bit longer before you're ready to be considered seriously for judicial appointment?
Thank you. I do appreciate that. I'm not just going to be hard in not having to listen to counsel. I'm open, I'm available, I can continue to act, and that is going to assist. But in respect of this matter, I've gone through it. It was the first constitutional matter, Commissioner. It was difficult. My nerves were just all over the show. So, but I had to give it my best because I had a responsibility in having to dispose with the matter and come up with an order. looking at it, I see the shortcomings, but I do appreciate the fact that I've learned one or two things, and having to hear from commissioners in respect of their comments, I'm taking them to cognizance. Thank you.
Thank you, DCJ.
Thank you, Deputy Chief Justice. Good morning, Advocate Bokako.
Good morning, Commissioner.
I must commend yourself. You've done well academically. You've really improved, and I'm really proud of you. But what I wanted to find out from you is, you know the briefing patterns that we really cry about. And I see that you have worked with the municipalities, you have worked with Johannesburg Roads Agency. Do they give you work in practice?
No.
At least the MEC is here. At least tell him that they must give you work in practice, so that at least you upskill yourself to all the issues that the commissioners are raising.
Yeah, no, I don't normally get, briefly, Commissioner, with that challenge, I think that's what actually led me to study. Because I realized that if one talks about transformation and having to be ready in receiving matters, I looked at it differently in that I seem not to have expectation of being transformed, but I think I have a duty, a personal duty, to transform myself. And that is why I decided really to continue with my studies so that I should be ready. I mean, even now, I'm dealing with my doctoral studies that talks to a land question which is fairly fundamental and topical. I'm just getting myself ready because it's something that is of moot, and there will be a need in our society in judges having to engage on the question of land. So that on its own, it becomes an enabler to me. But the issue of briefing pattern, it has been a challenge, and I think it's still a challenge. But it takes one also to make yourself relevant.
Okay, thank you. And the second, maybe advice, there are these courses on judgment writing. Do you normally see them?
Yes.
Yeah, or keep on attending them. I think it will work.
I'll do that.
Thanks.
Thank you, Commissioner.
Thank you, Commissioner. Commissioner Noches?
DCJ, unfortunately, the questions by Commissioner Baloyi defeated the very question I was to ask. So I withdraw. I'm not asking question.
Commissioner speak.
Thank you very much. Thank you very much, Deputy Chief Justice. Good morning, Ms.
Good morning, Commissioner.
Now, there is a matter which was raised by the professor there, and I'm interested in it.
Yes.
Professor was talking to sentences.
Yes.
And in a country where now everybody is up in arms about the high rate of crime, there was talk of concurrency of sentences. Don't know whether you call it concurrency or sentences running concurrently, but I know, and I've watched several cases where a person who's committed some of the most gruesome crimes, the person would be given 2 life sentences or 3 life sentences, but we know actually that 25 years down the line now, in the past it would have been 20, 25 years down the line the person will come out.
Yes.
I hear you say when the person eventually comes out, it doesn't matter if the person has served minimum sentence or not. You will still have the kind of reception which you would have had from the side of the public, which you would have had even if you were given a longer sentence than the life sentence. Because in South Africa, the life sentence is not life at all.
Yes.
And this is what people are complaining about. Now you say you have to deliver your judgment, you have to give a sentence, irrespective of how people may feel about it. That should not inform your decision.
Yes.
My question is, what then becomes the role of the judiciary in educating our people, in educating the ordinary woman and man, in educating even the victims of crime about what to expect and why they should expect that? Because I don't see you, I didn't hear you, your consent did not, maybe it's because that's how you should be as judges when you preside, but when we engage in this kind of forum, I would have wanted you to say, however, in spite of this kind of reception from ordinary citizens of the country, there is a need perhaps from the side of judges to do the following to educate our people.
Yes.
I didn't hear that. I just heard somebody who was saying, look, I do my work, I look at the legislation, I do things by the book, I give a minimum sentence, and how that minimum sentence is interpreted by your ordinary person and its impact on the victim is another matter.
I hear you, Commissioner.
Can you help me there?
In that particular aspect, yes. Commissioner, I think it borders to a principle in us having to uphold the rule of law, in that as much as we are individuals and the members of our communities, we still have a duty to promote the constitutional aspirations and the law that we're dealing with. And that's what confines us as judges. Without shying away that we are exposed to these ills within our communities, it will be inconsistent of us as judges to make determinations or craft judgments based on people's perceptions or community perceptions. Because if we stick to that, that is contrary to judicial independence. So it means continuously, if we'll have to do our job, we need to succumb to pressure, which I don't think is acceptable. But it doesn't really mean that we are immune as to what is happening around us. In writing our judgment on its own, a judgment is an educational tool on its own. It's a document that it's important. That is why the commissioners are posing the question of reasoning, to say for you to reach a conclusion in having to give only 1 life instead of 2, or only having to give 25 instead of 70 years, what led to that? So that reasoning aspect, the process that leads to that, it's educational. And the other aspect, Commissioner, is the access to courts, whereby we see our courts on a daily basis in our screen. That is educational on its own, because it makes a very knowledgeable society. They're exposed to what is happening. Yes, people will always have their views, their perceptions and opinions, but we really need to guard against emotions, because these emotions are fairly temporarily. It might happen for now. Circumstances in other cases could be different. So judiciary, there are a lot of publications that are there. There are a lot of bodies whereby judges, they actually attend these seminars. They get to talk. And we have seen with the Chief Justice in the past, which it was a little bit unconventional, the former, whereby he will talk about these things. People will get to understand what is the Constitution all about. That is educational on that. So our education, our judgment is educational. Thank you, Commissioner.
Judge?
Are you done? Okay.
DCJ.
Are there any questions from the commissioners on the virtual
DCJ.
platform? Oh, I'm so sorry.
DCJ. I'm a lay person, but I hate to say the manner in which you deal with this particular issue may sound extremely insensitive. The question I'm raising is, in view of what is currently going on, I'm not talking about pressure being applied on the judiciary. We respect the independence of the judiciary
Yes.
and the rule of law. Have we reached a point in our society where society needs to be educated and taken along to have an appreciation of why certain decisions are taken by the courts, such as just that which you've illustrated? For instance, you'll talk about 2 life terms, 3 life terms, and then you say as a judge, of course we know there's 1 life.
Yes.
You get my point?
I understand.
To a victim, you may as well appear to be extremely sensitive. To somebody who's lost a loved one, who will say to you, what is this 2 life terms, 3 life terms? And then you say, as a judge, after all, you only live once. There's
Yes.
only 1 life. So I'm just talking about, don't you see the need, in view of this uproar around sentences which are imposed on people who have committed gruesome crimes? Don't you see the need, not so much to change your penalty structure, but more about informing and educating South Africans, and perhaps that should come from the side of the judiciary itself, so that South Africans are not judgmental, so that South Africans are not impacted negatively by decisions of the courts.
I hear you now, Commissioner. Thank you. Apologies, I didn't mean to be insensitive, perhaps the manner I came across. I'm a very conscious person, Commissioner, when it comes particularly the plight of the accused persons and the plight of the victims. In that I don't only litigate on the basis that I win cases, but it's a consciousness that I have in me. When it comes to the judiciary having to be out there, having to teach the communities, I think it's primary. I think it's fundamental. But we really need to guard against a situation whereby we find ourselves entering into the space where we shouldn't. Perhaps suggestion could be we need to come up with civil social movements that will be out there specifically in having to promote the rule of law, specifically in having to talk about the culture of human rights. Because basically, if the society is not conscious on aspect of respecting one person, that is why we're in this situation. It's not only the judiciary that will have to keep this, but the society in all and in general has a duty to teach the communities. Our small social structures in our communities, they don't have to be formal structures. We have duties to teach our communities. I think if we can just look at one of my writings as to which body do I belong to, I belong to a structure within my community with women from Soweto. Those are elderly women which are exposed to crime on a daily basis. And their young children, mostly they're in jail. And they're sitting with little ones that do not have parents. So we look at the issues that if the person comes back, does the person has a second chance within the community? And we don't only look at the individual when she's back or he's back, the ex-convicts. We also look at the victims. I mean, you know for a fact that the correctional services had this victim dialogue session. We get to be involved in those processes to say, if you ought to be accepted, you need to take responsibility of the actions. And if I believe that if one person changes in the family, the whole community gets to change. So it's not only the judicial that has a responsibility, but cohesively, everybody has a role to play in capping crime and the ills within our communities. Thank you, Commissioner.
Commissioner Barnett?
Thank you, DCJ. Advocate Bokako, you speak about the rule of law, but I think that, part of the rule of law is knowing what the law is. So certainty, legal certainty we speak about. So sometimes you have conflicting judgments and you would go to a higher court to say, please, SCA or Constitutional Court, give us a direction in this matter. We have different judges with different things. The problem with your judgment is one of the points has been highlighted is there's an uncertainty within the judgment itself. So, for example, in the Mokotimi, Absa versus Mokotimi matter that was already referred to, where in the one paragraph you seem to say that cancellation of the agreement is important and the communication thereof to be able to get an interim interdict, but then 1, 2, 3, 4, 5 paragraphs later, you turn it around and you say cancellation of the agreement isn't important. And so the problem, for example, the GCB raises is one doesn't know, just looking within one judge, it's not even a conflicting two judgments, it's one judgment that says yes and no. It sounds a lot like the Afrikaans expression ja nee. You know, we don't know what to do with that, yes, no. So I think that's the problem, is the legal certainty. Please address the Commission on your attitude towards rule of law and legal certainty. Thank you.
I think in respect of legal certainty, it's when one really having to interpret the particular prescript in different contexts, be either having to contextualize it or by virtue of you having to interpret that particular prescript literally. That's about that. And then in respect of the rule of law, yes, I agree with you that having to express my views, it has to be clear, it has to be concise, and it ought to be practical. That's my answer.
Thank you, Advocate. Thank you, DCJ.
Thank you, Commissioner.
Thank you, Commissioner Bernard.
Sorry, DCJ, I just wanted to confirm just one small detail, that the Tefo judgment was concurred in by a senior judge.
Indeed.
Thank you, DCJ.
Thank you, Commissioner.
Thank you, Commissioners. Advocate Bokako, we've reached the end of your interview.
Sorry, DCJ.
Is there another question?
Sorry, I had my hand up for some time. I thought you'll recognize, but a very quick
Commissioner
one.
Singh, I'm sorry.
Thank
I
you,
was
ma'am.
not
Thank you.
alerted to your hand. Sorry about that.
Thank
I didn't
thank you,
even
ma'am.
know you were
Good
with us
morning,
today.
No, I am. Just yesterday I had a medical appointment. Good morning, Advocate. I'm on the virtual platform.
Thank you, Commissioner.
A little more clarity on the SARS matter, because, it's something that's worrying me. You completed your form on the 22nd of November last year, and you say that you are dealing with this matter, but this is an outstanding matter for the 2021 financial year, which would have ended in March.
Yes.
Can you tell us what is the quantum of how much you owe SARS? And when you say you are dealing with it, what do you mean? What are you saying to us, the Commission? Thank you.
If I may just recall, there have been different quantums because it started at about 91, but my consultant have actually filed a number of objections, and in respect of me having to file my returns, obviously it decreased the amount. So currently, I think I might be sitting at about 40,000, Commissioner. Obviously, this is information based on my consultants having to give me feedback. So we're just currently working on that. That is why I'm saying I've actually entered into arrangement having to pay that particular debt.
No, thank you very much. Now, the reason I asked that, if the Commission has to appoint any person to the bench that's owing SARS, which is an institution that we really hold in high esteem, then it'll make it difficult for us as a Commission. No, thank you very much. Thank you, DCJ.
Thank you, Commissioner Singh, and apologies once more for overlooking you.
No problem.
Any other question, colleagues? Are we done with this candidate? Thank you. Advocate Bokako, sorry. We have finished with your interview. Thank you very much for making the time to come and speak to us. You will know in due course what the result is, as you know. All the best.
Thank you, DCJ. I appreciate the invite. Thank you, Commissioners.
You're excused.
Thank you.